We propose
Let us proceed.
My Lord, we propose to begin with the application for mandatory bail.
This is we call the I don't know. We call
It's number what?
399.
39.
399.
Yes.
It's the one.
It's the one for mandatory bail. And Counsel Frederick Mpanga will open the arguments and we'll take it from there.
If it may please court, my lord. Frederick Mpanga, my lord. Criminal business application number 399. It's an application for a single order. You have the applicants. 399/2025. It is for a single order to admit the applicants. Retired Dr. Kizza Besigye and Hajj Oved Mutale mandatory bail. So that they are released from custody where they have been on remand since the 20th of November 2024. My lord, for brevity, the laws since November 20th November 2024. My lord, the provisions of the law under which the application is brought are stated in the notice of motion. The thrust is in Article 23, sub-Article 6, paragraph C of the Constitution of the Republic of Uganda. That application is supported by the affidavits of the applicants, and in response, when we joined the affidavits in response of the state, the applicants swore and were filed affidavits in rejoinder. Our colleagues, the state, were served with the affidavits, with the notice of motion, the affidavit in support, and the affidavits in reform. I wrote the uncontested facts that the applicants were arrested on the 16th of November 2024 in Nairobi. They are not contested. Reading the affidavits, those facts, the applicants were arrested on the 16th of November 2024 in Nairobi, Kenya, November 2024. They were produced and arraigned in the General Court Martial in Machinde. On the 20th of November 2024. On the 20th November 2024, my lord. You were charged with various offenses. Including offenses relating to security, contrary to section 128, subsection 1, paragraph F of the UPDF Act, Cap 330. I know they were charged with various offenses, some under the Firearms Act, but the one which is pertinent is offenses relating to security, contrary to section 128, section 1, paragraph F of the UPDF Act, Cap 330. And not we state that offense because the penalty for the said offense, if found guilty, is that the accused person suffers death.
Are you saying that somehow the charge in this application is under the UPDF Act?
I know there was a transfer.
Offense.
There was a transfer of proceedings to the magistrate court. So the
What
magistrate-
is the current?
the current one,
Yes.
following the transfer now,
Yes.
the charges were transferred from the general court martial to the civilian courts. At the Chief Magistrate's Court of Macau. And on the 21st of February 2025, the applicants were charged under Macau criminal case number 8 of 2025. For the offenses of treason,
This number?
8 of 2025. Uganda versus Colonel retired Dr. Kizza Besigye and Haji Obey retired. The captain, same process. My lord, the law is very clear. Article 23(6)(c) of the Constitution. That where a person is arrested in a criminal offense, tried only by the High Court, and who has been remanded in custody, or is on remand in custody, for 180 days before they are committed to the High Court. My lord, just for 6C, that where a person is arrested related for a criminal offense, in a case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such conditions as the court considers reasonable. My lord, in this case, we have stated that the 180 days accrued on the 19th of May and unlike what is stated in the affidavit in response, the applicants were committed to to the High Court for trial on the 29th of May 2025 and not the 26th of May 2025. But even though it was the 26th, which it is not, it was still the 188 days, 8 days after the expiry of the constitutional deadline. My Lord, that provision your learned brother, as he was then, the Honorable Mr. Justice Lamek Pasa, found that when the threshold of the 180 days has been met, the one in Article 23(6)(c), the 180 days has been met, the court has no discretion but rather has an obligation to release on bail. Its discretion only lies in determining the conditions of the release. And my Lord, in that matter, the state raised the point that at the time that application was heard for mandatory bail, there had been a committal. My Lord, that case is the scenario is similar to the one before your Lordship. That the accused, or the applicants for that matter, were in fact committed in the absence of their counsel on the 29th of May, 2025, 10 days after the 180 days had elapsed. The state in this case tried to argue that the application had been overtaken by events because there was a committal subsequent to the expiry of the 180 days. And my Lord, that is the position in the affidavit in reply, where the state, the deponent contends that this application is overtaken by events because of the committal on the 29th of May, 2025. My Lord, your learned brother Justice Lamek, as then was, found that the subsequent committal had no bearing on the application. Because by the time of the committal, the 180 days had accrued. So the constitutional deadline of 180 days had already materialized. So that the right of the applicant to mandatory bail had already arisen. The relevant part of the ruling, my Lord, reads that in the Eastern case, the applicant was charged on the 27th of June, 2011. By the time was committed to the High Court, I don't know whether I've lost you, so that. Yes, say that. Yes. So my lord, the court said that by the time I was committed to the High Court, the applicant had been on remand for more than 180 days. He was therefore already entitled to the constitutional right to bail, the only restriction being on such conditions as the court considered reasonable. And the court found that even in those circumstances, because of the mandatory right to bail, the exceptional circumstances for grant of bail did not arise. So we contend that even in this case, once the 180 days are ruled, it is not open to the state to require court to ask for exceptional circumstances. My lord, again, in the decision, your learned brother, as his name was, the Honorable Mr. Justice Cavallo, in the case of Joseph Luce versus Uganda, 1997, Volume 3, Kampala Law Reports at page 58. Again, in that case, my lord, the state opposed the right to mandatory bail by arguing that the applicant had subsequently been committed for trial and therefore he could not be released from bail. The committal having happened after the constitutional deadline. My lord, the court found that even though there had been a committal, provided he had been on remand for more than 360 days, and in brackets now 180 days, was corrected, such person shall be released on bail. And my lord, to settle the argument that there has been a subsequent committal, the Honorable Justice Mpanga'S stated that an accused person whose constitutional right to bail has accrued, an accused person whose constitutional right to bail has accrued, an accused person whose constitutional right to bail has accrued under the provisions of Article 23(6)(c) of the Constitution shall not automatically cease upon committal to the High Court. Shall not automatically cease upon committal to the High Court. So my lord, the fact that there was a committal, to the extent that it took place after 180 days, it did not in any way remove the right of the applicants to apply for bail. My lord, that position has been carried in the more recent decision. My lord, it is criminal witness application number 21 of 2025. Kizza Stephen versus Uganda. Kizza Stephen versus Uganda. Sorry, my lord. In that case, the Honorable Lady Justice Grace Flavia Lamuno my lord, the court in that case took a proactive approach in light of the rights of the applicant in that case, Mr. Besigye. And found that where in line with Article 23(6)(c) where in line with Article 23(6)(c) and Guideline 10(1) of the bail guidelines, a person charged with an offense tried only by the High Court who was being on remand for 180 days or more without committal must be released on bail. In that case, the court has no discretion to deny bail. My lord, the court took the view, which we align with, that to continue to hold such person in detention beyond this period without them having been committed is inconsistent and contrary to the constitutional guarantee of mandatory bail. My lord, the court taking a view that mandatory bail is guaranteed to an accused person by the Constitution, not the state, and most respectfully, not the court. It is the Constitution which guarantees this right to an accused person. And my lord, in that case, the proactive position taken by the court is that the applicant need not apply. Once the court, on its own calculation, finds that there has been a breach of the constitutional deadline, it must release that person. My lord, again, in Mpanga'S Robert versus Uganda, miscellaneous application number 29 of 2024. Your learned brother, the Honorable Mr. Justice Isaac Muat, found that the article and the guideline make it mandatory to release such a person on bail. The court only determines the conditions it considers reasonable for the release. But in the decision of Besigye, the court, over and above emphasizing the right of the applicant in that case to mandatory bail once the 180-day threshold has been met, cast a duty on the state in the event it is opposing bail. And my lord, the reason is that when the threshold is met, the Constitution affords the applicant a guarantee, so that if that guarantee is to be removed, it cannot be made or cannot be withheld on mere assertions. The court pronounced itself as follows: that the law places a burden on the state. The law places a burden on the state to provide compelling reasons to deny bail. To provide compelling reasons to deny bail once the constitutional threshold for mandatory bail is met. There is a duty on the state to provide compelling reasons why court should deny bail once the constitutional threshold for mandatory bail has been met. The court stated further, my lord, that mere assertions by the prosecution without evidence are insufficient to deny bail. Mere assertions are insufficient to deny the applicant's mandatory bail. The assertions must be proved. The assertions must be proved. Otherwise, there remain arguments which are merely speculative. There remain arguments that are merely speculative and which are not sufficient to override the applicant's entitlement to mandatory bail. The emphasis, my lord, we are making is that this is not ordinary bail, and that's why it's mandatory bail. It is a benefit or a right or a guarantee of the Constitution which accrues and is available for the benefit of an applicant once the 180 days accrue. So much so that there is a duty on the state, the burden shifts, to show with cogent evidence why that benefit should not be enjoyed by the applicant. My lord, that position again is stated in the case of Baguma Hassan versus Uganda, criminal misdemeanor application number 204 of 2023. It is also reiterated by learned brother, your are only speculative and cannot remove the right which is guaranteed by the Constitution, which has matured, has been the case in the matter before us. The first objection was that the applicants are not law-abiding. Because the charges against them emanate from participation and lawful act, where they took place, or when they took place, or the level of participation of the applicants. My lord, it is such statement which learned brother warned the court, mere assertions which are speculative and which fall far, far short of removing the entitlement of the and again, my Lord, in the Kizza Besigye reference 20 of 2005, the Constitutional Court pronounced itself that the constitutional dispensation in Uganda is that an accused person is presumed innocent until they are proven guilty. So in a scenario where the court has not pronounced itself on the activities and whether they are unlawful, it is not safe for the court to take that as a valid objection. My Lord, again in Baguma Hassan versus Uganda, Supra, which we referred to, it was exactly the same objection. Unlawful activities. The learned brother, the Honorable Justice Mwaka, found that that statement was a mere assertion which had to be disregarded. And that was a case where Mr. Kavuma had 8 charges of aggravated robbery. The court disregarded those statements. Now, the second objection by the state is in paragraph 5 of the affidavit in response. Sorry, I beg your pardon, paragraph 15 of the affidavit in response. The objections are the same for the trial, where the state says that the accused persons have not spent 180 days on remand. The state, however, admits that they have spent only 168 days. And my Lord, they base the calculation the court, the state contends that there are 168. 68. 168. We calculate from 21st February 2025 up to today, perhaps. And what we have submitted the case of Mwesi, where a young brother, in curing the lacuna caused by the Honorable Kabaziguruka petition, they appealed that petition for charges which stem from the General Court Martial. and also referring to the Kizza application, that the court must intervene where there is such a law. But it's not the making of the applicants, that the state pursued a course of action that was deemed unconstitutional by the Supreme Court. The applicants are merely victims of that unconstitutional order. So that the Supreme Court made a pronouncement the state wants to argue that those days when they were on remand should be brushed aside. That is wrong. And those points were covered by the Honorable Justice Mwata, page 3 to 5 of his ruling. Say that in matters of that nature, the court must invoke its inherent power to grant the accused bail. And that matters of bail applications in those cases must be, the proper court before they should be brought is the High Court. And I know the court was emphatic and grounded its decision of views in Article 126(2)(e) of the Constitution, that it administers justice without undue regard to technicalities. So, my lord, the lacuna caused by the pronouncement of the Supreme Court which impacted on the charges before the General Court Martial and the remand there, cannot be visited against the rights of the applicants. As victims of the process, they are entitled to take benefit. That is where the court comes in. Because it is the custodian of justice. My lord, criminal prosecution are such that all the resources of the state focus on an individual. In this case, the two individuals before your lordship. So that any breaches of the law of the state cannot be the fault of the applicant. And the state cannot be allowed to take benefit at the expense of the applicant. That was the view of Ivan Brother. And my lord, we are mindful of the fact that in this case there was a transfer. And that transfer is admitted in the affidavit of reply. But it would be absurd for the state to argue that it took over everything about the prosecution except their remand. That is absurd. So who remanded them? they were in a government facility. And my lord, DIP Ukundako accepts my lord, in their affidavit, I just want to emphasize that. My lord, in paragraph in paragraph 11 in particular, so my lord, paragraph 10, if I may read it. The first applicant, and in his evidence, he does state for himself and on behalf of the second applicant that on the 31st of January 2025, the Supreme Court of Uganda delivered judgment in the Constitutional Appeal number 2 of 2021, Attorney General versus Mpanga'S inter alia, that all trial of civilians before the General Court Martial was unconstitutional. In paragraph 11, that because of the Supreme Court judgment, we were not produced before the General Court Martial on the 3rd of February and were remanded in prison without any lawful remand warrants or charges. And my lord, in response, which is in paragraph 10 of the affidavit of Ukunda, that is an affidavit in reply to the first applicant's affidavit. He says in paragraph 10, in paragraph 9, the contents of paragraph 6, 8, 9, and 11, my lord, 11, which speaks to their being remanded without lawful warrants in the government prison. Mr. Kundakwe says that the contents in the applicant's affidavit are admitted to the extent of the charges against the first applicant, his appearance before the General Court Martial, his appearance before the General Court Martial, and remand to prison. So he's admitting that they will remand. That position is also the same in his response to the affidavit of the second applicant. And in regard to the second applicant, Mr. Kukundakwe avers in paragraph 7, he admits the charges against the applicant, his appearance in the court martial, and his remand. So, my lord, to the extent that the depot admits that they were on remand, and they stayed on remand, the court should cure the lacuna. And my lord, you should be mindful of the fact that there has been no break whatsoever from the events that unfolded in the General Court Martial. It has been a continuous process of remand after remand after remand, with not a second of liberty in between. So we invite the court to invoke its powers in Article 126(2), Rising Justice, 139(1) of the Constitution, Section 17 of the Judicature Act, to cure that lacuna, to prevent an abuse of process. It cannot be this court to argue that the remand between November 2024 and February 2025 was no remand. So the court cannot aid the state to commit wrong. We repeat, it's the same state under the veil of the General Court Martial, which manifested in the Nekawa Magistrates Court. The consistency is the remand, and perhaps the applicants. My Lord, be that the case, in the alternative and without prejudice to what we have said, in the unlikely event that the court should agree with the state that the 180 days should start from the charges at Nakawa, my Lord will say unlikely, because the court cannot ignore the fact that the applicants have been in custody since November. My Lord, the fallback position is found in the judgment of the court, of the Constitutional Court, in what we call the Kizza Besigye reference, number 20 of 2005. Number 20 of 2005, Uganda, PPP versus Kano retired Dr. Kizza Besigye. My Lord, in that decision, and which was reaffirmed in the constitutional petition number 20 of 2006, the court found that still under Article 23(6)(c), 23(6)(c), an accused person triable only by the High Court, triable by offense, charged with offenses triable only by the High Court, and who has not spent 180 days on remand can seek release on bail. And in that case, the court has the discretion to grant or not to grant bail if they fail to show exceptional circumstances. My Lord, the court found that that is the import, that is the only reason, that is one of the reasons, I beg your pardon, why there was amendment number, why there is the Trial on Indictment Amendment Act, number 9 of 1998. My Lord, that is the rationale for the Trial on Indictment Amendments Act number 9 of 1998. My My lord, the court argued that in such a case, where the applicant comes to court through this article, the court does not consider the conditions for ordinary bail. It only refuses to grant bail at discretion if the accused or the applicant fails to show or satisfy court about or regarding exceptional circumstances. And my lord, for brevity, one of the exceptional circumstances is age or advanced age. My lord, in the affidavit in reply of Ukundakwe, BIP, both in regard to the first applicant and the second applicant, he admits that both applicants are of advanced age. My lord, as we cross, as I cross, sorry, not we, I cross, because my colleague may want to add. The other objection has been in paragraph 20 and 22, that the accused will abscond from bail. Such plain statement was the case in the constitutional reference 20-205 and the Businje Stephen case. Again, it was a statement that the accused would abscond because of the gravity of the offenses. My lord, the court in that case found that that too was a plain statement, perhaps because the state was not expected to say anything else. My lord, we are mindful of the fact and has been shown in group annexure F of the first applicant's affidavit support. He has been charged several treason, misprision of treason, terrorism, rape, etc., and has not failed to meet any condition, because in all those cases have been used. My lord, in paragraph 23 of the affidavit in reply, because they are more or less the same. DIP Kukundane states that in the treason trial against the first applicant in 2016, he absconded. I don't take it that abscond must be a finding of court in order to show that there was an abscondment. But my lord, as shown in the affidavit rejoinder, that is not true. His sureties were never penalized, and in fact those charges were withdrawn. My Lord, the interesting aspect that in that allegation or statement, the state supports that with an ICMIS record. My Lord, to the extent that we are alive, we know that ICMIS was not there in 2017. So where the state is getting these things, we don't know. But that is the state. My Lord, there is an objection in paragraph 26 regarding the sureties. My colleagues will allude to that to save time. That your learned sister, the Honorable Justice Kania, in application 133 of 2025, found all the sureties substantial. My colleagues will submit that. And they are the same individuals. The state has not shown that there is any change regarding those sureties. But the other objection is in paragraph 27, which speaks to investigations. We are aware that there has been a committee so that investigations are placed. There are no investigations interfering. The other objection is in paragraph 28 and 29 regarding witnesses in Uganda, Kenya, Switzerland, and Greece. And that the applicants have associates in these countries. It is the same unsubstantiated allegation which the court in Procedure Stephen said should be disregarded. The associates are not left. And in the indictment, there was nothing to show that there was evidence from these countries. But in paragraph 30, the state contends that the followers of the applicants are violent. They threaten the court, they sing loudly, they hold press conferences, etc. The benefit we have today is that, my Lord, you are present. We didn't hear any hymns or songs for that matter. And we don't want you to take the view that your Lordship was scared or under attack. So, my Lord, we submit that the applicants have satisfied the requirement to be entitled. Lastly, my Lord, as I wind up my submission, as indeed the Constitution commands, this application was made in the lower court because the lower court is enjoined. And the power of the lower courts to do so have been the subject of court's findings by your learned brother, as he then was, the Honorable Mr. Justice FMS Gonatendo in Uganda versus Tesimana Rosemary. Massacre Criminal Revision 13 of 1999. Uganda versus Tesimana Rosemary. Criminal Revisional Cause Massacre, number 13 of 1999. Criminal Revisional Cause, number 13 of 1999. And again, the Honorable Mr. Justice FMS Gonantende, and then was in Criminal Revisional Cause Massacre, number 5 of 1999. That one is Shabukuria Matia versus Uganda. My Lord, the court, the High Court, informed the lower court that it had power to intervene in delays of this nature to avert a miscarriage of justice. What we have seen, my Lord, is that the lower courts have been shy or meek or timid to do the right thing. So, my Lord, it is a breath of fresh air that we are before a High Court, which we believe will not be shy, will not be timid, and will not act under any influence, as the learned brothers found in the Tumwesi jail matter. We invite court, my lords, to invoke the bold spirit and not be timorous. So that an abuse of process and a miscarriage of justice is averted. My Lord, I'm closing. I just want to make a final remark. My Lord, we refer, my Lord, to a land author, Lord Alfred Thompson Denny, in his publication, The Discipline of Law, London, 1979, at page 315. My Lord, if I may quote as I conclude my remarks. Say that if the powerful still abuse their powers without restraint, if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls. It is thanks to the dominant influence of timorous souls. Semicolon. Bold spirits will not let that stand. And bold spirits will not let any rule of law Holy Spirit will not let stand any rule of law which impairs the doing of justice. They will do all they legitimately can do to avoid that rule. Even change it so as to do justice in the instant case before them. My Lord, it's our prayer, as my colleagues come, that the court will adopt, unlike the courts below, a bold spirit so that justice is done in the matter before us. My Lord, my colleagues have some.
May it please you, my Lord, I intend to address you in two specific areas, or rather issues. The first one is about the spirit of mandatory bail. The spirit